today. I'd like to call them to order. I call this meeting to order at 9:42 a.m. There are two matters that are on the docket today. The Los Angeles Department of Water and Power case number 1263-80, for which we would take after we hear South Coast AQMD versus Baker Commodity Inc. 6223-1. I'd like to state for the record that Dr. Abraham is attending remotely. Dr. Abraham, your location has been posted pursuant to the Brown Act,
Correct.
and your location is accessible to the public.
Correct.
Okay, let the record reflect that he's agreed that his location has been properly posted and is accessible to the public. Madam Clerk, are there any individuals online desirous of providing any public comment or evidentiary testimony?
No raised hands online.
All right, thank you very kindly. We would take case number 6223-1 first. Before we do that, are there any witnesses that either side will proffer today?
Chairman Ali, George Jiganis for Baker Commodities. We have Jason Andrioli ready. If the hearing board wishes to hear from him, he's available remotely. But if there's not a need, then we don't have a specific reason to provide testimony.
Okay.
And the district also has two witnesses that are available, Atul Kandahari and Paolo Angoni, who can be called to testify if the hearing board desires to hear them.
All right. So who's representing the petitioner today?
Chairman Ali, are you the respondent? Are you the petitioner?
On behalf of the district, who was the original petitioner for the order for abatement, Nick Dwyer and Daphne Sue.
All right, and the respondent / petitioner.
George Jiganis, a DLA Piper for Baker Commodities Inc., as well as Caroline Lee.
All right. So we will swear in those individuals if in fact members of the hearing board have questions. But at this moment in time, we will go ahead and allow the petitioner to provide opening arguments, opening statements.
Sure. Good morning, Chair and members of the board. We're here today for a status hearing related to the order of abatement as it was modified on July 2nd, 2024, allowing Baker to start its collection activity as its permits to construct enclosures are being processed. Baker started its collection activity on October 14th. Baker's permits to construct are progressing through the permitting process. There are a total of 4 relevant permits. The 2 permits to construct and temporary permits to operate for raw material enclosure, which includes the screw conveyor that would be needed for expanding Baker's collection activity, and the J&M plant skimmer trash bin enclosure have been issued by the district. The other 2 permits to construct and temporary permits to operate for the trap grease area enclosure and the Centrisis trash bin enclosure have been submitted to the EPA for its 45-day review. And the district anticipates by January 14th, 2025, for the latter of the 2 to be issued. The district objects to Baker's purported status report insofar as it argues Rule 415 applicability in relation to the permits. The only appropriate section of the purported status report is Section 2, which is related to the use of the deodorizer. Condition 12 of the modified order asked for a feasibility analysis regarding the deodorizer. Any argument regarding permits is inappropriate at this hearing. There are procedural due process concerns with receiving argument, testimony related to permit appeals. Deliberations would be improper as well. If that is an issue Baker desires to pursue, then it may appeal the permit. During the permitting process, the district took a hard look at whether 415 applied to a facility that processes trap grease along with operating a collection center, and concluded 415 applies to such a facility. Permitting engineers confirmed Baker's Vernon facility continued to be a rendering facility since it processes trap grease and collects rendering material. Any limited stipulation regarding 415 for the modified abatement order was limited to the abatement order context. Once again, we object to any argument or testimony related to a permit appeal for this hearing. For the current order for abatement and conditions, after the permits to construct are issued for the enclosures over the trash pit area, the J&M skimmer trash bin, and Centrisis trash bin, then Baker is to complete the construction within 120 days. If the last permit to construct for the Centrisis trash bin enclosure is issued on or about January 14th, 2025, then 120 days is May 14th, 2025. We request another status hearing to be set on or about June 18th, 2025, at which time we can confirm whether the enclosures were built as agreed upon, or if they were, then we would agree to the expiration of the order for abatement. That concludes my opening statement.
Right, to the respondent, opening argument.
Thank you, Chairman. Since July 2nd, Baker has done everything the hearing board has asked in everything that the parties carefully discussed and negotiated in what was entered as the second modified order on abatement. I'm happy to report that the operations that Baker has undertaken have been successful. We did do a feasibility analysis regarding the deodorant that member Balagopalan had in particular discussed. And happily, after that feasibility analysis was submitted, we were able to identify, or the company was able to identify a deodorant that it could use on the product and has been using to good effect. There have been no odor complaints. There have been a couple of submitted complaints that were investigated and found to have been about not about this facility or otherwise incorrect. So the facility has operated without complaint since it began this operation on October 14. We don't have an issue, and we do think that a further status conference after the period for construction of the enclosures would be appropriate. And regarding the application of Rule 415, the only thing I would say, we do not intend to argue the application of Rule 415 at today's hearing, but I would say that it's easier for the district to not to mention that issue or not to discuss that issue in front of this hearing board, but this is Baker's business. And it is, I hope, evident to the hearing board after essentially a year of discussion and hearing that Baker is making every possible effort to keep its union employees employed, to keep the Southern California area receiving these very important services. And an issue like the applicability of Rule 415 or its lack of applicability is important to Baker. So we do want to keep the hearing board apprised of the discussions and the permitting activity that's going on, but do not intend to argue the substance of that issue today.
All right, Mr. Dwyer.
I have no witnesses.
Okay.
I thought you said you may have two witnesses. I do have a question. Yeah, if-
They're available.
can I-
So would you
I
like
do
to
have a
have?
question for the inspector. One of the condition is to go inspect the facility, so I wanted to get a report back, what he found, what he observed. And also, while they may not have received notice of violation, did the district receive any notice of violation? So I'd like to know that.
Let me a brief recess and go get him for you.
So why don't we take about 15 minutes? We'll take about 15 minutes. So let's say we'll come back at 10:15.
Okay.
Just make it easy. All right, we're off the record.
Uh, Chair, if we need to mark some exhibits, oh, okay. There was a letter that they sent before. Right.
Back there over there, we got a problem, we just, it was an issue.
Hmm. Which one? For which case? Yeah, they sent, after the hearing, they sent a letter sometime in July based on their, research, saying that they, hang on, I think I might have. That's the only one they sent after the hearing. I thought I printed it, but let me see. This was, August 9th, 2024. There was a letter regarding the, odor suppression evaluation. You want me to forward it to you? No. Oh, that would, you have to go to the fine, what do you call, minute order, yeah. Okay, here. That seems to be my own. At the back, I think you'll see the exhibit numbers.
Your jacket. Your jacket right there. You must click on some more.
I think in the front it says 7:22, the hearing.
What is it?
One of course when I liked it, but they're two separate colors, so I always buy two. And then I end up having a bunch of those.
Multiple colorways.
Just, yeah. Out here. See. I know. Did you hear what I wanted to ask you about the issue?
Walk to the
Yeah.
Wait, I did forward. I did now, just now, yeah, after you left.
No, that's a different case we're talking about.
Yeah, I'm talking about a different case. Sorry.
So this is the only one for the day. This is one exhibit.
What is that? Yeah. And the letter dated August 9th. I don't know if you want to put that, August 9th. There was a letter sent August 9th regarding the deodorant odor suppression investigation. Well, let's go on the record and again, okay.
So I don't believe we need all the time, so we'll go ahead and just let's come back. You're gonna leave right around first. All right, Dr. Abraham, our distinguished witness is here, so we will go ahead and go back on the record.
Sounds good.
Okay, we're back on the record at 10:01 a.m. I just wanted to be very clear, we wanted to mark before we provide the oath and ensure that our witnesses can testify accordingly. Want to mark the exhibits. The respondents submitted the exhibit. The respondents are alphabetical. And so the last exhibit was KK. This exhibit will be LL. This is the Respondent Baker Commodities, Inc. Status Hearing Report dated December 18, 2024. Again, that's LL. Mr. Balakapalan, you believe that there ought to be another?
Yes, there was a letter sent by the the law firm DL Piper, on August 9, 2024, the report on the odor suppressant investigation that Mr. Joe Giggins alluded to. So that was sent, let me see when it was sent. August 14th. We received it on August 14th.
May I?
Go right ahead, sir.
Just the only thing I would add is that the letter was submitted confidentially. It does include business confidential information. So to
Oh,
the extent
okay.
it's
All right.
entered as an exhibit, if we could identify it that way. Or if there's a process for entering it as a confidential exhibit.
All right, so the document wouldn't be posted?
No, they don't want it posted then.
No.
No.
Mr. Pearman?
Is anyone insisting it's part of the record?
No.
No.
And you can leave it out if you want.
Okay, very well. So then the only exhibit submitted today would be LL as described before. And so let me jump over to the, one second. All right, so why don't we go ahead and just simply provide the oath for all witnesses? Can we bring the other gentleman online? Just in case members of the board have questions. Oh, there he is. All right. So if you stand, if both witnesses would stand. Oh, he's, okay. All right, do we, what, no, don't worry. If he's not here, then we can, did it just, okay, there he is. He's joining. Okay, that's Andreoli. Okay, very well. Mr. Andreoli, if you can. All right, can you stand, sir? Raise your right hand.
So I can stand.
All right, there we go. Do you solemnly state on the penalty of perjury that the evidence that you shall give in this matter should be the truth, the whole truth, and nothing but the truth?
I do.
All right, the record is clear that both witnesses, in fact, took the oath. And so at this moment in time, Mr. Dwyer would ask you to call your first witness.
All right. Paolo Mangoni from the district is here to take any questions that the hearing board may have, and if respondents have any questions of him.
Just for the record, Mr. Longoni, you want to give your title and how long you work for the district?
Can you repeat that, please?
Just for the record, can you give your title and how long you work for the district?
Oh, yeah. My title, I'm Paolo Longoni. I'm an Air Quality Inspector 3, and I've been at the district for almost 17 years.
Okay. Mr. Longoni, yeah, when did you go inspect the facility the last time you were out there?
Last time was November 7, 2024.
2024. This is after they started the operation, correct?
Correct.
All right. And there was a condition in the previous order, number 11, I believe that, are you familiar with that? That they cannot use the collection center until they demonstrated the use of the loading and unloading equipment. I believe this is something that the district wanted included. So did you go and observe the loading and unloading equipment?
No, I personally didn't. I personally didn't. I know other member of the district did, but I wasn't there that day.
No. Oh, okay. Who inspected that operation then?
I honestly don't know.
You don't know. So did you get any feedback from their observation of the operation? Because there was a condition saying they cannot start operation until it was, there was a demonstration to an inspector, I assume, or an engineer. So
I think there were members from the engineering department, but not from compliance.
Not from compliance?
Oh, sorry. I said there were members from the engineering department, but not members from the compliance department.
Okay. Do you know, did they give any feedback to you saying that what they observed was demonstrated to be adequate and so forth?
Not to me personally.
Okay. So when you were there, were they applying the odor suppressant?
No, when we were there, they have not yet received that day any delivery. So the enclosure was empty, was clean, but we didn't observe any of this transloading operation as we were there.
All right. One last question then. Have you got any complaints since the last hearing regarding this specific operation, the transloading operation? Any complaints?
I don't personally respond to the complaints. I have the statistics. They were compiled by our senior enforcement manager, but I don't respond personally to complaints.
Are you aware of any complaints is my question. Regarding just the transloading operation.
Since the transloading operation started and going forward 2 months, the district have received 22 total rendering complaints.
What complaint? I'm sorry?
22, from October 15, 2024 to December 17, 2024. The district received 22 total rendering complaints.
22 random, you said?
Rendering,
Random,
yes.
okay.
3 of these specifically named Baker as the source, and 1 named Darling. Darling, D-A-R-L-I-N-G.
And that's Darling Ingredients, the other rendering facility.
Correct.
So 3 for Baker was, did anybody respond? Do you know?
I believe so, but the inspector that did respond is out sick today.
Oh, I see. So you don't know at this time it was related to the transloading operation or not?
No, I can't testify to that.
Okay, I have no further questions. Thank you.
Thank you.
On cross, or actually any other members of the hearing board? All right, did you want to provide any cross-examination? Go right ahead.
Yes, hello. So we are aware of so first I'll speak to the odor complaints. We are aware of 2 complaints received naming Baker specifically, both of which were investigated and determined not to have been sourced at the facility, and no odors were emanating from the facility.
Is there a cross-examination of this gentleman?
Sorry. Okay, sorry. I'll direct it to you, sir. So we understand that one of the complaints was the City of Vernon, Department of Health, and did you receive the official inspection report for that from December 9th?
No, I've not. Again, I did not personally investigate those complaints.
Okay. Well, we're happy to provide the district a copy with the final inspection report for that, which does confirm that there was no rendering activities or inactive rendering equipment at the facility at the time of the inspection. It also confirms no animal carcasses were observed at the facility at the time of the inspection, and there's no evidence of foul odor stemming from rendering activities at the time of the inspection. And that's dated December 9th, 2024, from the City of Vernon Department of Health and Environmental Control. So we can provide that for you. That was a follow-up to one of the complaints that we understand the district received.
I think for the record, we would prefer for that to just be entered into it as an exhibit rather than having counsel testify about the contents of the document.
I would agree with Mr. Dwyer. So can we have that document entered as an exhibit?
Yes, Chairman. If I may ask a few questions of Mr. Longo.
Go right ahead, sir.
Thank you, sir. So Mr. Langoni, did you mentioned that there were 22 total rendering complaints from October 15th to a recent date in December. Is that correct?
That is correct.
But what do you mean by rendering complaints? What does that mean?
I haven't personally seen those, but I can assume that possibly they mention a rendering odor.
Okay, so they're odor complaints.
Correct.
Okay, and that 3 of those complaints named Baker as a source.
Correct.
Did you review any of the complaints that you mentioned?
No, I have not.
who would have reviewed the complaints that named Baker as a source?
Most likely the inspector that responded to them,
And who was that?
Michael Pua,
Could you spell his name?
Michael, last name Pua, Pua.
And how did Michael Pua respond to those three complaints, if you know?
No, I don't, sorry.
Do you know whether he visited the facility?
I don't know.
Do you know whether anyone visited Baker's facility as a result of the complaints that you mentioned?
No,
Do you know whether the district communicated those complaints to Baker?
I don't know.
Do you know whether the district has communicated any odor complaints to Baker since October 14th?
I don't know.
Okay. Is there a witness who does know that the district has ready if they would like to make an issue of odor complaints in this hearing?
We don't want to make an issue of odor complaints at this hearing. And Michael Pua, we intended for him to be available,
Is that an
but
objection? Are we objecting? Are we?
I was just explaining that.
I
Michael
was
Pua.
asking a question of the witness, but I'm happy to have a discussion outside of the examination. My concern,
Yeah,
Chairman, is
I would concur with that, but we definitely want to keep the questioning direct to witnesses and not a colloquy.
so my question for the record to the witness is there a person at the district who does know what the district did in response to these complaints, to your knowledge?
If there is a person, that would be Michael Pua.
Okay. Mr. Longoni, you are a member of the compliance team at the district, correct?
Correct.
And part of your purview is the Baker facility, correct?
Mostly limited to the order of abatement because geographically I live like an hour and a half away, so it would be kind of complicated to respond daily to complaints.
Understood, and that was probably an unclear question. All I mean is that one of the things that you do in your duties is deal with the Baker facility to the extent that there are odor issues or complaints. Is that correct?
Recently, I'm limited to reviewing their monthly record that they submit each month. I review them. I review this balance sheet to make sure they comply with the 60,000 pound limit. That's mostly what I'm limited to recently.
Are you aware of any confirmed report of odor problems at the Baker facility since October 14th?
You mean confirm order as specifying the definition of the rule with 3 complaints received?
No, what I mean is you mentioned that there are 3 complaints that mention Baker as a source. Am I correct in assuming that the district did something in response to those complaints?
I would say yes, but not sure.
Are you aware of the district confirming odor problems or any complaint of odor at the Baker facility since October 14th?
You mean something that resulted in a violation or?
Any confirmation of odor actually emanating from the Baker facility giving rise to a
I
complaint?
could not respond to that, sorry.
Okay. Earlier, my colleague had mentioned another inspection by the city of Vernon. Do you understand that the city of Vernon will sometimes inspect facilities within its jurisdiction, including the Baker facility?
I could not respond to that, sorry.
And was it ever communicated to you that the city of Vernon inspected the Baker facility on December 9th?
No,
Did anyone ever communicate to you that when the city of Vernon inspected the Baker facility, whether on December 9th or another date?
Objection just assumes facts not in evidence.
Question's not completed, so I'd appreciate it if council would wait till I
The
complete.
objection is overruled, sir. Continue on with your questioning.
Thank you. Are you aware of any time the city of Vernon inspected the Baker facility, whether on December 9th or on another date, and confirmed that the Baker facility was conducting no rendering activities?
no,
So no one has communicated that to you from the district?
no,
Has anyone from the district communicated to you that under the same circumstances, the city of Vernon concluded that there were no foul odors stemming from the facility?
no.
Okay. Would you expect to have that knowledge if you were called to testify as a witness regarding odor complaints at the Baker facility?
You mean if I were the inspector that actually responded to this complaint?
Well, I mean, if your counsel brought you here to testify in response to questions from the hearing board regarding complaints at the Baker facility, would you expect to have that knowledge?
Like I said, my only knowledge was about the stats that were compiled by my senior enforcement manager in anticipation of probably a question coming from either the board or you.
Okay, if Chairman, may I address the board briefly to see if we could short circuit some of this examination?
Well, what I'd like to do is if we don't have any additional questions from the witness, we can dismiss the witness. And then we can allow everyone an opportunity to expedite the process. But do we have any more questions of the gentleman?
I don't think I have any more questions of Mr. Langoni, and I do appreciate your time. And
Oh, thank you so much.
Are there any additional questions from members of the board?
Yeah, I did have follow. Mr. Longo, you knew you were going to testify today?
I knew.
Then why didn't you prepare for, why didn't you talk to your colleague and get some background? You said you review the order, that's your role, and there is a condition 11 that requires the inspection, before they start the operation, and you mentioned that somebody else did. Why didn't you check with that individual to find out what he observed or if he has written a report, and then also get more and have more details on the 3 complaints while you knew that you had to, you're coming here and to most of the questions you say, I don't know. So why are you here as a witness is my question then,
Well, actually, the testimony was supposed to be split between me and Michael Poor, me for the part that I did, the inspection that I did in November, and he was supposed to do the part about the complaint. We had a meeting scheduled yesterday, but Michael called in sick yesterday and today, so I had no chance to talk to him.
Okay. So when you went there on November 12th,
Number 7th,
there was no operation going on.
No.
So did you consider going up for doing a follow-up, asking them when they will have material in and do a follow-up inspection so you can observe the materials or transloading operation?
No, I did not consider. I just reviewed their records, like I said. Their records received every month.
All right. I have no further question. Thank you.
All right, any additional questions from members of the hearing board? If not, we'll dismiss the witness. Thank you, sir. Okay, Mr. Dwyer, did you have any additional?
I do not, but Atul Kanhari, he is available and he may be able to answer some of member Balagopan's questions about this inspection referenced in condition 11. So we can call him.
And I appreciate that. But if you can check, if he knows, if he's not the one who went there, then there's no point bringing him because we're going to hear the same thing. I don't know. So if you can confirm that he did the inspection prior to the operation, then having him testify will be, so that way we can verify the compliance of condition number 11. That's all. I'm looking for some confirmation that this was conducted, and that's all. But if he doesn't know, if he's not the right person, then, no point calling him.
All right, so Mr. Dwyer, I assume you rest?
Yes, arrest.
Okay, respondent.
Chairman, we are happy to call Mr. Andrioli if necessary. My chief concern here, I actually don't think that there is a significant factual dispute between the district and Baker regarding what's happened at the facility. My chief concern is that the record very clearly reflect that there have been no odor complaints that have been verified at this facility. People call and make odor complaints about different things, and there's no control over what those people may report. They are followed by inspections, and those inspections have very, very clearly shown that this facility is in compliance. There are not foul odors stemming from this facility. There is not rendering occurring at this facility. And given the testimony, I think it's very important that the record reflect that. As long as it does, we don't need to put this hearing board through Mr. Andrioli's testimony on it. But
If I'm,
So what we're going to kind of go out of order a little bit. Just want to make sure everyone is comfortable with deviating from the normal process. So I'm going to turn the floor over to Mr. Balako-Palan so that there can be some discussion as you requested.
Thank you.
And I think it would be useful to hear Mr. Andreoli because we didn't hear the information from the inspector, but more than likely he was a point of contact when Mr. Pua did the follow-up inspection, or if the engineer did the inspection also. So maybe he's the point of contact and he can shed some light on it, who came there and if they did show up on those 3 complaints or not at the facility, that's all.
Certainly.
So that's the only reason to call him.
Ms. Verdugo Peralta.
It's very relevant. This thing on, I think it's very relevant that we do hear from that one inspector, and to circumvent it, maybe you need to ask him specifically in reference to Mr. Balako-Palan's question, whether he has that information or not, because I would like to hear it for one.
So the inspector, Michael Pua, he called out sick yesterday.
I
He had a
understand that, but
fever,
wasn't there
so-
a third one?
The other one that I suggested, the engineer, I believe he was at the facility and did inspect, but I don't know specifically if it was in reference to condition 11. So I wouldn't know without asking him.
And Mr. Androli may be the one who can shed light on this, so we can close this matter, So that's why I suggested we call Mr. Androli.
Well, I don't object to that, but I would also like to hear it from the district.
I think Mr. Andreoli likely would have relevant testimony about when this inspection occurred related to condition 11, and that could clarify this for member Balako-Palan. So I see no issue with calling him for that purpose.
Okay, so let me ask you this. Is there any documentation relative to the inspection? Some notes or anything taken, perhaps that can be entered as an exhibit? Because they're going to enter into an exhibit, a document from the city of Vernon. That'll be exhibit MM for the record. That'll be exhibit MM. So are there any documentation or additional exhibits for which we can read just to make certain, because we do want to land this plane today and not all day?
I'm not aware of any
Okay, all right, fair
document for
enough.
that.
I have to go back through my email, but I believe there was a notice sent to the district that all conditions under 11A have been satisfied and transloading would begin. And that letter preceded actual transloading beginning.
Okay, so why don't we do this? Counselor, you can question Andreoli. We'll give the chance for the district to engage in the hearing board. Your co-pilot can locate that email. We can get it over to the clerk, enter it as an exhibit, and then we can move the process forward. But what we don't want to do is kind of get stuck in the ditch this morning. So why don't we go ahead and, as Mr. Dwyer said, Dwyer rather, Mr. Andreoli can perhaps provide a little context. So why don't you go ahead and call your witness?
Absolutely. Well, Chairman, we'll do exactly that. Mr. Andreoli, can you hear us here?
I can. Can you hear me?
Yes, we can.
Wonderful.
I think the procedure is for the hearing board to have the first opportunity, correct? So
The attorneys first.
Yeah, the attorneys would have a first bite at the apple, but
okay,
but you kind of can walk through some of the questions because you know where we are at this juncture.
excellent. So then, Jason, if you can first of all spell your last name for us for the court reporter.
Sure. My last name's Andreoli, Andreoli.
And Jason, what is your role at Baker Commodities facility?
I'm the general manager of the Los Angeles facility.
Okay. And so, Mr. Andreoli, you are aware that the attachment A to the findings and decisions granting the second modified order for abatement that was issued by this hearing board contains various conditions some of which are required to be done before Baker can start its transloading operation, correct?
Correct.
And you've reviewed that document previously, correct?
Yes.
And section 11 of attachment A says, is titled Collections, Operations, Conditions. You've reviewed that section, correct?
I have.
And section 11A says Baker shall not use the facility as a collection center until 1, it has conducted a demonstration of the use of loading and unloading equipment with roll-up doors closed and truck inside the enclosure. You're familiar with that condition?
Yes, I am.
And did that demonstration occur?
Yes, it did.
Do you recall approximately when it occurred?
I think it was early October.
And do you remember, if you can, who from the district attended that demonstration?
There was a few inspectors. I can't remember all of them. From my recollection, it was 2 of them were Jason Aspel and the tool.
And could you spell those names for the court reporter?
I will do my best. Jason Aspel, Jason, Aspel, Easpell, and the tools Atul, and
Is it Kandar?
I believe so.
No, Kantari. That's perhaps the district could give us an assist here on the spelling of the last name.
Yes, it's Kandhari.
And so, Jason, you recall that Atul Kandari was at the demonstration?
I believe so, yes.
And as a part of what you do in your job, are you made aware of correspondence that may come from my firm or my office going to the district?
I'm aware of it. I may not see all of it, but most of the time I work with our in-house, and as you know, I work with you guys as well.
Yeah, and do you recall instructing our office to send a letter to the district confirming that this demonstration had occurred prior to transloading operations occurring?
Yes.
And if I could, I would show you a letter that's dated October 11th of 2024 that without reading it here, it's a short letter, short 2-paragraph letter that does indeed confirm to the district that that demonstration occurred prior to October 11th. Do you recall seeing that letter and instructing that it be sent?
I do.
Okay, so are we at NN? Is that?
Correct. We're at NN.
So we will arrange for an exhibit NN, which is my firm's October 11th, 2024 letter to the district confirming the satisfaction of section 11A of attachment A prior to the commencement of transloading operations.
If I may, we would like to see copies of exhibits MM and NN prior to it being submitted, or so we have an opportunity to see what the documents are.
Not a problem.
Thank you.
Not a problem at all.
Certainly. Yes. Yes, we'll do so. You've seen it, for the record, we'll keep it clean, but you've seen all of these. Mr. Andrioli, a few more questions for you.
Sure.
After the operations for transloading commenced, did you receive or were you involved in any other on-site inspections, whether by the district or by anyone else up to today?
Personally, I was not.
And were there any members of your team who were involved in those inspections?
Yes.
Any such inspections?
There was a City of Vernon inspection that happened a little over a week ago.
Sorry. Can you repeat that one more time?
We have a court reporter, sir. Can you repeat that loudly?
I apologize.
time?
There was an inspection that happened a little over a week ago.
And who conducted that inspection?
I think it was Lionel Gutierrez and Frank Tabacoli.
Those were the Baker Commodities employees who conducted the inspection. Was there a member of the city of Vernon who inspected the facility?
Yes, there was.
Okay, and did Mr. Tavacoli or his colleague report to you about that inspection?
Yes, that is correct.
And did you receive a report of the inspection from the city of Vernon?
Yes,
And did you review it?
I did.
Did that report conclude that there was any foul odor stemming from rendering activities at the facility?
The report concluded there was no foul odor.
Did that report conclude that there were any rendering activities occurring at the facility?
The report concluded there was no rendering operations going on at the facility.
Okay, and did the report conclude that there was any inactive rendering equipment left at the facility?
The report concluded there was no active equipment going on in the facility for rendering.
Mr. Andreoli, to your knowledge, has any inspection of the facility confirmed any report of odors stemming from the transloading operations occurring at the facility since October 14th?
There is no confirmed odor at the facility since we started transloading.
Okay, thank you, sir. I believe that concludes my question.
The district, the witness is yours.
We have no further questions for the witness.
Thank you. Members of the governing board, Mr. Balakapalan.
Morning, Mr. Andreoli. I just wanted to check if we're submitting that as an exhibit from the city of Vernon also.
Yes, sir.
Okay, so that'll be, and then so it's OO,
I believe that will be MM.
OM? Oh, okay.
Yes, they've already.
I thought that was the other one. Okay. Mr. Andreoli, so I don't know if you heard the previous testimony from Mr. Paul Longoni, that he had in his three reports that were three odor complaints that were attributed to Baker. Have you heard of, did anybody follow up with you or Mr. Tavacoli about these odors? Did anybody show up on to investigate those three odors?
I don't recollect.
Okay. So there's no, and then let me go back to the demonstration. So you said Mr. Aspel, who is from the air monitoring group, and Mr. Atul Kandari were there, and they observed the operation. Did they express any concern, any issues with what they observed?
Not that I saw, or from what I remember they said. It was just confirmation of what our plans were, and they saw, from what I can tell, that it worked fine.
Did they give you any kind of verbal saying, hey, we are satisfied, you can start your collection operation?
Yes, like as stated, it was a couple months ago, but from what I remember, yes.
Okay. All right, I have no further questions. Thank you.
Any additional questions from members of the board? Mr. Dwyer?
I just want to be heard about this exhibit, MM. We just want to confirm that we can review it and object in case we have any concerns about it before it's entered into evidence. Because we have not seen this Vernon NOV report that was created this past week or whatever it was.
Perfect. Okay, perfect. So let me ask you this. How much, ma'am? Floor is yours.
I was just going to say I can email it right now if that's appropriate.
So Mr. Dwyer, how much time would you need to review?
How long is the
The
document?
document is one page. I can show it to you electronically here.
A few minutes.
Okay, very well. So we're gonna, Madam Clerk?
Yeah.
Yes. So no, everything will be emailed to the clerk for the record. But he's letting Mr. Dwyer see that being collegial and collaborative. Mr. Balakapalan?
Yeah, I thought there was one more, which is the letter that the law firm sent to the district saying, that Is that, are you providing that also?
Yes, that will be exhibit N is in
That's
Nancy.
NN, okay.
that's NN.
All right, that is NN, okay. So we'll get both. Okay.
All right, we're off the record for about 3 minutes. Yes. Or we'll have it emailed to us.
Can we go back on the record?
Okay, I just want to confirm that the clerk has received all the documents. Okay. Oh, absolutely, absolutely. Electronically. Okay, okay, we need a hard copy, okay. No problemo.
Or do we remain off the record?
Okay. All right,
I just sent.
okay. She sent them and said, we'll get a hard copy. All right, we're gonna go back on the record. We're back on the record at 10:40 a.m. All right, Mr. Dwyer.
Having reviewed Exhibit MM and NN, we have no objection to those being entered into evidence if so desired.
All right. Responded.
We appreciate the district's comments. Chairman, there is one other record that we could either enter as an exhibit or otherwise deal with, and that is a memo to the file from Frank Tavacoli. The district would not have seen this. It addresses an odor complaint that the district received that Mr. Pua, who was mentioned earlier, communicated with Mr. Tavacoli about, investigated, and found was not emanating from the Baker facility. It's a business record of Baker's. I don't need to enter it as an exhibit as long as the district can confirm that they agree that there have been no confirmed odor complaint or no odor complaints confirmed to have been emanating from this facility.
So are you comfortable with that document becoming public?
This is a business record, but does not reflect business confidential information. So yes.
Let's enter it as an exhibit. Oh,
That's simply.
Yeah, we have no objection to that being entered into evidence. But we would want to review it first.
okay, fair enough, fair enough. So can we get can we get that new document also sent to the clerk?
Yes, sir.
Thank you very kindly. I know it's very difficult to judge what documents folks would want to enter as exhibits, but I would encourage we send documents earlier and most certainly have hard copies, at least 6 hard copies, 5 for the, or 7, whether it's respondent or petitioner, 5 for the board and 1 for the clerk in the future, just to be able to move a little bit more efficiently. So Madam Clerk, there's an additional document coming over that's Exhibit 00, for which the district needs an opportunity to review, as well as the members of the hearing board. While the district does not object, they still would like to review the document in fairness.
Chairman, I believe we have given the district that document on my phone,
Okay.
and they have reviewed.
All right, so then we'll have the document sent over to the clerk's office and then the clerk's office will send it to the hearing board.
And there's no objection to that being entered into as for evidence from the district's perspective.
Thank you. Members of the hearing board had an opportunity to review the documents that were sent. Yes, we have all the documents that have been sent by email. Not a problem, no, take. Okay, so why don't we go back off the record for about another 3 minutes and give it, you sure? Okay, all right. We want to make sure did we send OO to the, okay, very well. OO is, why don't you describe OO just one more time?
Yes, Chairman. OO is an email from Frank Tavicoli to Jason Andrioli. That is a memo to the file. It describes a telephone conversation from Mr. Michael Pua from the district to Frank. He told him that on December 6th, there was an odor complaint against the Baker Vernon facility. Michael added that he investigated and found out that the odor was not from our facility. Mr. Tavicoli adds that he told Michael that every day in the morning, he checks the enclosure, that it's all clean and that no odor can be detected from the enclosure.
All right, so we'll move to closing statements.
I do want to state on the record that we don't object to the document actually being entered into as evidence, but we do have hearsay objections to it being taken for the truth of the matter asserted within the document, because he's not here to testify about those conversations with Michael Pua, and Michael Pua is not here to testify about those conversations. So it has less value given those limitations to the evidence, but.
And those objections are hereby sustained. All right, Counselor.
Chairman, are you asking for comment on the
Closing.
objection? Closing.
Well, if you want to wrap the comment relative to the objection within your closing remarks, please do so.
Certainly. Thank you, sir. I would note that the document is a clear business record and an exception to the hearsay rule, but most importantly, I believe that what the board has heard today is that the district and Baker agree that there have been no verified odor complaints from the operations that have been occurring at Baker's facility since approximately October 14th. And that the district and Baker agree that Baker has complied with the pre-operation condition, specifically regarding the demonstration of equipment within the enclosure. And so that Baker, the primary point here is that Baker has done everything within its power to respond to and to hear the hearing board's concerns that we had discussed in detail over the course of 3 hearings, and that the district and Baker worked collaboratively to develop a set of conditions by which we all agreed, and the hearing board, of course, facilitated and contributed importantly to those discussions, that Baker could begin its transloading operation. And since that transloading operation has begun, Baker has complied with all of the conditions. There have been, again, no verified odor complaints. Baker has added odor suppressant to the material at the facility and is otherwise, in our client's view, very well poised to continue these transloading operations under the modified order of abatement, and ultimately, when disputes about the permits are resolved, to continue its operations under the district's long-term permits. We very much appreciate the hearing board's attention and care in this matter over the course of now 4 hearings, or probably more. And we remain optimistic that Baker's Transloading's operations can be a success. It is very important that they are for the Southern California area and for Baker's employees.
Thank you, thank you. Let's dismiss Mr. Andreoli. He can log off. We see him as a panelist. All right, members of the hearing board, we're moving to deliberation.
Well, they haven't done district as a closing yet.
Yes, yeah.
Well, we just have a few closing remarks.
Okay, I called for closing and you provided objections, but go right ahead.
So we agree with Baker that if the order for abatement and the conditions that have been worked out for the order for abatement have been working, and the district has not seen odor issues here because of these conditions in place and because of how that has changed the operations at Baker. So we want to continue this order for abatement and have a status hearing on June 18th, if we could, to confirm that the conditions are still being complied with, and confirm that the 3 small enclosures that are referenced in the conditions are constructed as permitted. That's all we have for.
All right, members of the hearing board.
I
Mr.
think-
Pearman.
We can find good cause to issue the single modification to set a status conference on June 18th.
Mr. Valakapalani?
Yeah, I'm actually quite disappointed with the district's witness. And I mean, we should have heard not, from the district witness regarding these conditions and what they observed, and, and instead we heard from the inspector is, I don't know, mostly, on the day he went there were no operation. But, I'm not disputing what we heard from Baker's witness, that everything, there's no odor, and complaints have been looked at, and City of Vernon, I appreciate getting that from the, the letter from the City of Vernon, but we should have got something from the district also, why we, this is a status update, and the inspector came totally unprepared for it. If Mr. Poor is sick, he should at least, he could have got the report from him, or, or talk to the engineer who was there for the inspection, and we would have, been convinced, okay, everything, is operating as per listed in the condition. So that I really am disappointed on that. So I'm hoping that the next status update, we don't have this a repeat of this performance today, that we have somebody, who has gone through these conditions and verified they are all operating as per the conditions, not, I don't know what's going on, So that's the only thing I had an issue with, I'm glad that they did find another alternative material that they can apply on the raw materials to reduce the odor, and I like to hear from the inspector also, how effective that is too, if he's been, that's why I asked Mr. Longo if he was there before and after. So how effective that is, in suppressing the odors. So that would be a useful thing. And I do agree, I think, not to belabor the point, I think the issue of 415 should be done at a different time if there's an appeal on the permit that is issued, not at this juncture, even though we did get the letter regarding 415 rule for applicability. So I think that should be deferred if there's an appeal. So other than that, I do agree with the payment. I do find good cause to continue this order and we get a status update on June 18. Again, I want to emphasize, really, we shouldn't get some report from the district inspector, even if they cannot appear if they're sick, at least a written report. We got a good report from City of Vernon, what they observed, that something like that, would be very useful. That's all I have to say.
Ms. Verdugo Peralta?
Thank you, Mr. Chair. I concur completely with Mr. Balagopalan. I also think it's the responsibility of the district to make sure that your witnesses are going to be providing relevant information. If there in fact was a issue with one of the sections of the agreement, then obviously we need that inspector's information. If you knew yesterday that this guy was ill, why couldn't we get a declaration from him at the very least? But somebody from the district should have been here for us to be able to question, for us to be able to verify that everything that was coming from Baker is indeed fact. Let me say one more thing. We've come a long way from where we began, and I appreciate all of the work, and I know it has not been easy and it has not been cheap to do everything that Baker has done. I appreciate that, not only for the surrounding communities, but also for the actual employees who are right there. But it's taken, I think, both sides to work together. And I think we on the district side have failed as of today. As far as a report, we got a good report from Baker, but I don't think we got anything really from the district. And I would have thought the district would have been much better prepared. And I'm very disappointed with that. Hoping that come June, all of the questions you can anticipate and hopefully give us the information that we've been looking for. Thank you.
Any additional questions? Dr. Abraham, comments?
I would just agree with a lot of the comments that have been previously made and really do hope that we can have some of those issues addressed from the district side. You know, we have supervisors, managers, directors, we have colleagues. We call out, I work in a hospital and clinic. We have to have better answers. And I appreciate, both sides trying to be as best prepared as possible, but shared many of the concerns that were raised by my fellow hearing board members. Thank you.
Thank you very kindly. The matter of facility ID number 800016, case number 6223-1. I move that we find good cause to continue the order of abatement, receive and file Baker Commodity Status Hearing Report, and set a status hearing for June 11th, 2025.
18th, I believe. Is it 18th?
Why the 18th?
That's what Mr. Dyer.
Something might happen.
Well, but we just assume by May 14th, the construction of the 3 enclosures would likely be complete, or we'd be able to report back on whether it's been complete. So there's like a wiggle room of a month or so there. So that's why we chose June 18th. It could be June 11th if the board prefers that.
June 11th.
So we spoke with the district prior to today about a June hearing, and due to previously set conflicts, June 11th may not work, but June 18th looks like it will work.
The 18th it is. Is there a second to the motion?
Second.
Second by Ms. Verdugo Peralta. Any further question or discussion on the motion? All right. Hearing none. Dr. Abraham, your vote?
Aye.
Ms. Verdugo Peralta?
Aye.
Mr. Balakaplan?
Aye.
Mr. Chairman?
Aye.
Ali votes in the affirmative. The matter is hereby approved unanimously. You guys have a phenomenal morning. See you June 18th, 2025.
Thank you, Chairman. Thank you, members.
Thank you.
All right. Allow us to continue rolling. We're going to move quickly to the consent calendar item.
Minutes,
Absolutely.
because I did forward the
Not a problem.
document to you, Faye. I don't know if you want to give it to.
We're off the record until 11:05 a.m.
Yeah, I just, I thought of the whole thing, but I think it's,
I just need to print the one.
with just the one, yeah, with the one that has the underline and the,
Or you want the strike out?
yeah, I think they didn't clean it up or anything, you know. I don't, yeah, they didn't, they just accepted and sent it.
Hey, Mohan, your
Oh.
microphone is on. Someone's microphone is on.
Back on the record. All right, back on the record at 11:07 a.m. As stated, we have case number 1263-80, consent calendar item modification of a final completion date and extension of a variance rules 20322, 2004 and 3002. And so we want to mark a few exhibits. There's a stipulation to place the matter on the consent calendar. That would be exhibit number 8. Really? Okay, okay. What I saw was, I thought the petitioner's exhibit, I'm looking off the minute order dated 6. Okay, is it the wrong minute order? Okay, well, okay, you're 100% right. Let me back out of this. Okay. All right. So the stipulation, Madam Clerk, you said is number 6? Okay. And then the declaration of Ian Guthrie for the City of Los Angeles acting by and through the Los Angeles Department of Water and Power to the hearing board is exhibit number 7. And then is there a HB exhibit? That's right. 8 is proposed findings.
Number 9 is also proposed finding for the red line.
Yeah, and you have a copy, just, I think Faye just handed it out with the red line version.
Yep,
That'll be-
I see that.
That'll be 9. And then there's HB2.
Okay, 9 and there's HB2. All right.
Can I ask a question?
Go right ahead,
So
Mr. Pearman.
Does 8 reflect your changes?
No, 9
We have to
does.
go with 9.
Yeah, we have to go with 9, yeah.
If we agree with the change.
Yeah, I thought they will just accept it and send the, but they didn't, they sent the same document.
Okay. All right, any discussion? Members of the board relative to this matter?
Well, I can start. I think this matter has come before us. They came for interim variance and also and then a regular variance. What they're coming before us now is a modification and extension of the final compliance date. And since this is going to go beyond a year, they have to do a schedule of increment progress, which they did include. I think the change I made was really I think in this particular one, they just said notify the inspector, but I just wanted to clarify that they need to submit a variance petition if they want to modify the schedule of increment of progress, as required by the health and safety code. And that was so the delay is beyond the control. It's again, the blades, the turbine blades have still been ordered, been manufactured, and they won't expect to get it until January of this year, next year. And then they have a number of tasks to reinstall it, retest it, and so forth before they do the actual testing. So I think in the abundance of caution, they're asking for a test date of January 15, 2026. Hopefully they will do that way before that. But anyway, that's the because things will unexpectedly can occur, with the repair of the unit number 2. So I do believe they made the requisite finding so we can make the good cause finding to grant the modification and extend the final compliance date with the schedule of increment of progress that was listed in exhibit number 9. That's all I had,
All right, any additional comments? Okay. All right. In the matter of facility ID number 800074, case number 1263-80, I move that we find good cause to grant the request for extension modification as set forth in the proposed findings and decisions, exhibit number 9. Period.
Just one, I'm sorry, Mr. Ali, friendly amendment. on page 1, I did strike out when I did my edits of 40825 should be 40826. The new number was not put in. It's on the first,
Yes.
so it should be 40826, Madam Clerk.
Okay, section 40826. Let that amendment be noted. Is there a second to the motion?
Second,
Second by Dr. Abraham. Any further question or discussion? Hearing none. Dr. Abraham, your vote?
aye.
Ms. Paducah Peralta?
Aye.
Mr. Balaka Palan?
Aye.
Aye. And Ali votes in the affirmative. The matter is hereby approved unanimously. And we're done with our docket for today. So Madam Clerk, while we're here and present, so Mr. Balaka Palan, you're absent tomorrow and the 31st?
No, just the 31st.
Okay, okay. And we'll be able to have appropriate coverage the 31st. Okay,
Yeah, I think it's
perfect, perfect. All right, if there's no further question, comment, and or discussion, we are adjourned for the day at 11:13 a.m.
So on the very first reading, I saw a paper.
Yes, yes, yes. Both of those cases will more than likely come consent, yes. All right, we're adjourned and off the record.
Bye-bye.
Is everybody gonna be here tomorrow?
I'll be remote.
Oh, you do? Oh.
We're off the record, Mr. Day.
Are you guys